Hello, my name is David Petrosky. I'm a landlord attorney representing landlords on eviction cases throughout California. Today I'm going to be discussing the 3-day notice to pay rent or quit. It's a very popular notice because it's used to terminate a tenancy in California when the tenant stops paying rent. First, I'd like to tell you a little bit about myself. I've been representing landlords since 2004. I'm consistently rated as a 5-star law firm on Yelp and other websites. I'm a published author and a prominent referral source for realtors, landlords, and attorneys. Today's presentation is going to be divided into 3 sections. I will first discuss the purpose of the 3-day notice to pay rent or quit, followed by its usefulness, and finally we'll end on some guidance. Let's talk about the purpose. A 3-day notice to pay rent or quit is used to terminate a California tenancy due to the tenant failing to pay the rent. Here, the tenant has failed to meet his or her obligations to pay rent, and the tenant is at fault. This is different than a no-fault eviction where the landlord is giving the tenant, say, a 30 or 60-day notice simply to terminate the month-to-month agreement. But here we can use a 3-day notice because the tenant is at fault and they have failed to pay their rent when the rent was due. The goal for the landlord is to regain possession of the property as quickly as possible, plus receive a money judgment for the past due rent and possible holdover damages. The usefulness of the 3-day notice is to terminate a tenancy quickly if the tenant fails to comply with the notice. So what I mean by that is we serve the tenant with a 3-day notice to pay rent or quit. He has 3 days to either pay the rent or move out of the property. And if he does neither of those 2 things, then we would have to file an eviction case or an unlawful detainer in court. And to reiterate, the landlord is requesting possession of the property plus money damages for the past due rent. Now let's discuss the guidance section. You're going to want to read and become familiar with California Code of Civil Procedure Section 1161-2. You can only demand past due rent, no late fees. This is a big gotcha because a lot of times landlords who are not knowing how to properly complete a 3-day notice for non-payment of rent will include late fees on the notice. Just recently I had 2 cases where the landlord did this and they lost the case because of that. You cannot include late fees on the 3-day notice. As a separate issue, late fees are frowned upon, and a lot of times a landlord shouldn't charge late fees anyway. But going back to the 3-day notice for non-payment of rent, you cannot put late fees on the notice. Another problem area for landlords is that you cannot include more than 1 year of past due rent on the 3-day notice. And to me it's odd because I would think if a tenant stops paying the rent, a landlord would want to take action right away to minimize their loss. But there are some landlords who will wait and not start the eviction process for a long time, sometimes even longer than a year. But again, you can only demand past due rent up to the previous 1 year on the 3-day notice. Another problem area for landlords is that if the lease is under the name of a corporation or an LLC, on the 3-day notice where you're telling the tenant how to make the payment, you need to put an individual person's name on there. So you could say something like, make payment to ABC Corporation, care of John Smith, or something along these lines, but you must put a real person's name in that make payment to section on the notice. That's relatively new, but it's been happening in the courts a lot where judges will throw these cases out if you don't put a real person's name there. You will also want to include the contact information for the landlord, address, phone number, how to contact the landlord. Include the full property address, street, city, zip code. And another very important thing to consider is that you cannot overstate the amount of rent due. If the rent is $1,500 a month and you put on the 3-day notice $1,501, or even if you put $1,501, then you'll lose the case because you will have overstated the amount of rent due. It's safe normally to underestimate the amount of rent and go under what is actually due, but you can't go over. That would be a fatal flaw to your eviction case, and you would lose. Now, you're going to want to serve the 3-day notice to pay rent or quit in accordance with CCP, which is California Code of Civil Procedure 1162. And what that says is that you're going to have to either serve it personally, or you're going to have to subserve it, or you're going to have to post and mail. It's better to have this done by a process server who is not biased and who can make sure that they get it done correctly. You're going to want to count the 3-day notice correctly. The first day starts on the day after the notice is served, and then the 3 days would include weekends. However, if the third day falls on a Saturday or Sunday or holiday, then the tenant would get until the next business day. So for example, if you serve the notice on a Wednesday, then the first day would be Thursday, second day would be Friday, third day would be Saturday, but because the third day is on a weekend, they would get until Monday, end of day, to pay or move out of the property. On the other hand, if you serve the notice on a Monday, then they would get Tuesday, Wednesday, and Thursday would be the third day. You don't want to make any side deals with the tenant. Let the notice speak for itself. Don't accept any partial payments either. If you accept a partial payment, then you will have waived that 3-day notice to pay rent or quit, and you'd have to serve a new 3-day notice for the balance that is owed. The next step: if the tenant complies with the notice and pays the rent or moves out of the property, then there's nothing else for you to do. On the other hand, if the tenant fails to pay the rent or move out of the property, you'll then need to file an unlawful detainer action in court, and that's something that we can help you with if you're in one of our service areas. Now I'd like to tell you some additional resources for your own use. On our website, which is attorneydavid.com, again that's attorneydavid.com, we offer many forms for landlords, many of which are free and available for download. Go visit our website, attorneydavid.com, download our free forms. Also, check out our evictions blog. We publish articles on there regularly with a lot of landlord-tenant information and eviction best practices. And finally, if you're in one of our service areas, we do offer free consultations for landlords, no obligation. Finally, if you haven't done so already, please subscribe to our YouTube channel. We will post many videos with helpful information and tips for landlords. And if you have any questions, give us a call. Visit our website, attorneydavid.com. Thank you very much.